I beg to mention for listing of the read petition. The matter has become discussed tomorrow, next week, Wednesday. Okay. Therefore, listing a content critical project. So, not to direct the register official of register management to release the undue amount of it. They are not that's why we file this content critical. What has column of it? Anytime.
Okay, oh, to release the undue matter and the content matter.
Yes.
You ask the history.
But we already approached for.
Okay, give it. Right, Mr. B. Borgohain, then passes for the petitioner to submit that the petitioner's contractual dues have not been paid in terms of the order dated 21/5/25, passed in WPC 106 of 2020. Correct? 2024. And the order is of
Annexure 5, page number 25.
21/5/25 in WPC 106 of 2025.
That is another matter.
But that is another matter. No. Which
In this case, MQ notary is Annexure 5, page number 25.
page number 25.
25.
So this is what?
WPC number 204.
Huh? Page number
25, Annexure 5.
25 in Asia 5. It's WPC 106 of 2025. Then is there some other order? This is the order. 2025. Right, no one appears for the petition of the matter pertains to non-payment of dues in terms of the order dated 13/5/24, passed in WPC 4994 of 2020. Issue notice returnable in for which petitioner will take steps for service of notice upon responding within 3 days. Is the matter of the court. Same order, same, no one appears, huh? Then, use everything, after the writ petition number will be 4949 of 22. Yeah. Same order. Yes, I heard Mr. J. Sharma, learned counsel for the petitioner, who submits that the petitioner has not been paid his one-time permanent alimony pursuant to the order dated 25/11/24, passed in matrimonial appeal number 34 of 2018. Should it be before this court?
He might not civil bench one matter, my lord.
Then, ah, uh, 2018. As the matter pertains to civil bench one, this is the matter before the concerned bill.
Lordship issue notice at this stage. But
I am doing
because
it won't be proper. I can issue, I don't have a
yes,
problem.
yes, yes.
But would not be proper. Let's go to the concerned bill.
My lord.
This is the matter before the appropriate bench.
Obliging. Regarding cerebral violence with 5 years, there was some. And now my 300 as per and I think the marking is law.
Will issue notice.
Minor.
Basically, that SP order is causing the problem, correct? Okay, right. Heard Mr. A. Rashid, learned counsel for the petition to submit that the that the letter dated 1/11 2022, impugned letter dated 1/11/22. Issued by the Superintendent of Police bracket DSP, Baksa, page 13. By memo number BSA/DSP/296/2022/1968. And requested the Deputy Commissioner Baksa to stop the 5 cattle markets in Baksa district from being operated. We have 5 districts. One of them being the, which one are you interested in? Mr. Counsel, for which cattle market are you interested?
Sonapur cattle market.
But Sonapur cattle market is not here in this page 13. The Sonapur cattle market is not here. So how will this letter affect you?
Page 11.
Page 11. Yes.
Ask material number 1.
Huh?
That is the number. Under PDP. They are not in any effect.
Maybe. But your case is that it is because of this SP letter that Sonapur cattle market is not being settled.
They are
But-
not 15 million, only they have by the days delay 13 million, by which period they have given the distance from the international border to that period. I think 20 million our case is the period, and our narrow power method is Sonapur cattle.
I am dismissing your writ petition, Mr. Counsel, because you're not being fair to the court.
No, not then.
You see, this letter pertains to only 5 cattle markets. What have I said?
If it have Monday million, I
Which are as follows?
Monday.
There is 1, 2, 3, 4, 5.
No,
Huh?
if
Full
it
stop.
have Monday, I
Next
take-
para. The petitioner's counsel submits that the petitioner is interested in operating the Sonapur cattle market. And due to the letter dated 1/11/2020 issued by the SP DSB Baksa, no NIT is being issued with regard to the Sonapur cattle market. So, next para. Where is the representation?
No, I have not filed anything.
Huh?
No, only I have to.
Then you go to the next para. On considering. No. Mr. On perusing the impugned letter dated 1/11/22 issued by the SP DSP Baksa, it is seen that there is no bar for the Deputy Commissioner Baksa to settle the Sonapur cattle market, as no request for stopping operation of the Sonapur cattle market is reflected in the letter dated 1/11/22. Next paragraph. The above being said, this court finds that the petitioner has not submitted any representation to the Deputy Commissioner Baksa.
Only I have closed.
Where? Where is that?
Only million I have.
Orally, no. Orally, so you can approach everyone. You can approach the President of America also. So what have I said?
Then I will be allowed liberty not to approve.
That's what I'm giving you. Bye. How do I put? You see, Baksa, for settling the Sonapur Cattle Market. After issuance of NNI. This court is of the view that the petitioner should first approach the Deputy Commissioner Baksa with his grievance. And depending upon the reply to be given, the petitioner may approach this court again. Mr. S. Datta submits that. Mr. MKP, the council for
Response number 4,
4, 5, and 6, and Ms. P. Papa for response number 1. Also submit that if the petitioner files the representation to the respondent number 4, the decision should be taken by the respondent number 4 to the petitioner's representative. This time. In view of the consent of the party, the petitioner is given the liberty to submit a representation to the Deputy District Commissioner Baksa with regard to his grievance. In the event the petitioner submits his representation, the District Commission should take a decision on the said representation within a period of 1 month from the date of receipt of the representation and communicate the decision to the petitioner. The petition accordingly disposed of. Not this case disposed of. Item?
Item.
Yes. Didi,
On payment.
okay, right. Heard, Mr.
SN.
S.
SN.
S.N. Adhyapak, Learned Counsel for the petition to submit that despite the petitioner having completed the contract work, the final bill of the petitioner has not been paid. Issue notice returnable in 4 weeks. Mr. M. Ketia accept notice on behalf of
1, 3, 5, and 6.
1, 3, 5, and 6, while Mr. A. Charlie accept notice on behalf of response number 2 and 4. Petitioner will take step for service of notice on the respondents number 7 and 8 by registered for the daily within 3 days. This is the matter of proposal. 7 also same. Party is also all same.
Same.
Okay, same order. Right, Mr. M. Ali for the petitioner.
Lord.
Also heard Mr. M. Ketia for point number 5. Miss P. Barwa for point number 2. Anybody else? What about 6? Superintendent of Police, Deputy Commissioner. Yes, there you call them. Yes, Mr. P. Naik, what to do? You're the AG. It's a D voter. This has to. No, the notice is not required. You just have to direct the SP to do the.
Take up this after.
It'll be here now. You cannot go according to their will. Huh? Please call them. Item 9. Next. Heard, Mr. A.R. Medi,
PCR में.
PCR Medi, Learned Counsel for the petition, who submits that despite the contract work having been completed, the contractual dues of the petition has not been paid. If you notice, returnable in 4 weeks. Who accepts notice?
This is my payment.
Huh?
For payment of the.
I know, contractual due.
That's why I'm appearing for respond number 14586.
It's the P9 accept notice on their phone number 1, 4, 5, and 6.
Is appearing for respond number 3 lots.
Miss R. Barwa pays for point number 3. What about for 2?
2 lots with one Cape one is paid.
Who?
Cape one, own up.
A. Fokana pays for point number 2. This is the matter. After 4 weeks, enable the respondents to file the affidavit.
Cancer patient is the
Huh?
Father is a cancer patient. He is Kamu.
Mr. Counsel, when did you finish your contract work? Which year? Which year did you finish your contract work? Huh?
2024.
202. And straight away you come to court. Some time has to be given. Fishery, highest bidder,
Yes. Certainly, the highest bidder of the
then,
highest value bidder.
then,
And I inquiry,
okay.
you were
Mr.
MK Goldberg.
N.K. Kalita learned counsel for the petitioner submits that despite being the highest bidder, the fishery has not been settled with the petitioner till date. Mr. P. Sharma appearing for the
State Department.
fishery department submits that he will obtain instructions within a week. Within a week. This is the matter on.
Who are you?
When do you want?
Friday.
So we have got M. Chetty and Ms. P. Barwa we have got already, no? Yes, Mr. J. paying for
For respondent number 2, 3, 5 and 7.
2, 3, 5, and 6.
7.
There's no 7. Ms. P. Barwa, you are appearing for 2. And Mr. M. Chetty is appearing for
5.
5, no?
Yes.
Then, so J. Paying is appearing for
3, 4 and 6.
3, 4, and 6. Huh? Okay, so your it is with regard to which year?
2005.
2005, correct? So it's D6611.
Got
Voters list 39, number Jaleshwar LAC.
Got
Part 23,
And village Katari.
village,
Katari.
you write, huh? Village Katarihat. Village, how do you spell Katarihat?
Kaearihar.
HU,
HAR.
Katari, Hari,
Katari.
Hara, HARA.
Yes, of unauthorized construction. In fact, one of the municipal board, they directly stopped doing the work, but now they are not enforcing the own order. So construction is going on at least.
Who is appearing for the GMC?
So here, the Disco municipal board, they do not have a standing council in Disco.
Okay, right. Third, Mr.
Okay, then.
A. Ganguly, learned counsel for the petitioner who submit that the respondent number 6 is constructing a building by encroaching upon the land of the petitioner. He also submits that where is the authority's letter?
I'm not granting the permission.
No, saying that it is there anything to show that he has been encroaching?
Well, the authority had stopped the work.
Where is that?
Order is at page 38.
So
Line is the translation.
it's still continuing despite the order.
Yes, then
Is
after
there
that,
some
seven-
stay order? Is there some stay order or something?
Yes, this is the stop work order.
No, but is there a stay order or the stop work order? He also he also submits that despite the executive officer, Tezpur Municipal Board having issued a letter to the respondent number 6, directing him to stop the construction work. Actually, this letter dated
12/7/2024.
12/7/24, directing the respondent number 6 to stop the construction work. Come on, the respondent number 6 is still continuing with the work in question. Issue notice returnable in 4 weeks. The same Chetty accepts notice on behalf of
1, 2, 3, and 4.
1, 2, 3, and 4. Petitioner takes steps for service of notice upon the respondents number 5 and 6
Testing in addition.
by registered post within 3 days. In addition to the above, the petitioner shall also serve notice upon the respondents number 5 and 6 by way of drastic service and file affidavit of service later. This is the matter. Leave it.
Maybe it's clear the pending that-
Next date, let us be, because this,
that
you see,
also-
this here, this is the matter on pencil. On the next date, the petitioner's prayer for an interim order will be considered. Because this is of July 24,
Yes, it's about there.
1 year has gone.
Getting sort of allowing her to continue. It's a difficult.
And then let's see.
Giving the challenge is to annex a 7/802.
802, let us,
This is the findings of the technical bid evaluation by law, in which the bid of this particular in respect of a tender for building construction has been rejected. My lord. There are two grounds, my lord. One, they say that, my lord, the power of attorney of the director to sign the contract. Secondly, the memorandum of association of the contract was not so.
then,
These two, my lord, find mention in page 61, my lord. Page 61, clause 3.4, my lord. If the bidder is a limited company or corporation, the application shall be signed by a duly authorized person. Holding power of attorney for signing the application accompanied by a copy of power of attorney. Bidder should also furnish a copy of the memorandum of particular of the bond. This clause is.
the application shall be signed by a duly authorized person holding power of attorney for signing the application, accompanied by a copy of the power of attorney.
And also.
The
a copy of
bidder
the-
should also furnish a copy of the memorandum. So it is here.
My lord, this is clear, but then, my lord, if your lordship comes to page 40,
40.
these are the list of documents to be uploaded.
Yeah,
The list of documents to be uploaded, my lord, this do not find any mention.
huh?
There's no mention of the power of attorney in bill of constitution in this list of documents to be uploaded. And as far as the power of attorney is concerned, my lord, we have taken the plea of section 21 of the company law. That if it is a company who is filing application or a tender,
We have to.
the signing authority is vested with the director, my lord.
Bidder, just a minute. So where is the power of attorney?
No, that's not there in the list of documents to be uploaded. So it is finding a mention in a clause subsequently, my lord, thing there. What I am therefore insisting is that, my lord, this power of attorney is not a mandatory clause. Because anyways, a company can always be represented by its director.
But then,
I did not appoint any agent to sign on my. If I appoint one of my employees to sign on my behalf, I need to give him a power of attorney. But section 21 is very.
when the author of a tender requires something to be done.
I know.
How can you say, no, it should be this way?
But because
They are the ones who are going to spend their money.
So
If they want you to dress in a yellow shirt, they can ask you to wear a yellow shirt.
that yellow shirt might not be reasonable. Because
May
section
not be,
21,
may not be reasonable is a different thing.
I understand.
That is as per the, that is the discretion given to a
Right.
authority.
As far as everyone is concerned, my lord, the law is clear.
This is because,
Section 21, my lord, you have picked up the Companies Act.
no, are you challenging this clause?
No, my lord.
If you're not challenging the
I am
clause,
not
then
challenging the
where's the question?
I'm not challenging the clause because the,
Look, if
though the
you are,
clause is there, I'm saying it's not a mandatory clause. Because what are
then
the
we have to let
mandatory
us,
documents to be uploaded, they have given a separately.
I don't know, we'll have to ask them because they are the ones who can decide whether it is mandatory or not. There's nothing for the court to decide.
Because why I'm saying, because when the Companies Act says that the director is empowered,
Look, you are not challenging the clause.
my lord.
So if you are not challenging the clause has to be upheld. And whether it is mandatory or ancillary will depend upon the interpretation to be given by the author of the tender.
My lord, just clause 3.4, if read with clause 20 that I pointed out, my lord, it creates a confusion. He said that these are the documents you have to upload. And I understand that these are the documents that are required actually to evaluate my technical field, my work experience, my financial capability. These are the documents based on which it is evaluated. The existence of the company otherwise cannot be in doubt because we are already a registered PWD contractor.
No. Anyway, do you have a power of attorney
But we have,
that the person who signed the tender document,
my lord,
does he have a power of attorney?
no, my lord, he has the board of supervision. Because section 21 of the Companies Act says that, specifically, my lord, it is on authentication of documents, proceedings and contract. So as far as the company is concerned, if when a director himself come forward to sign, he only needs a board intervention. But then if I send my manager to sign, or somebody other than the class of person that is mentioned in section.
The best I can
21,
do
will
is,
give him a power of attorney.
the best I can do is I can issue notice.
As far as the memorandum of association is concerned, my lord, since it is not listed in the documents to be uploaded, my lord. Ultimately, as per clause 20 is the documents that we have uploaded.
Yeah, the clause says that it should be done in a certain way. You have not put that clause to challenge. How can you say that no, it has to be done this, it can be done this way?
So they
You have to
themselves
put
have created the ambiguity, man.
Huh?
That these two documents be listed in this list of documents to be uploaded, man.
Yes,
They have created this ambiguity. It has to be now interpreted in my favor, man. Lot of it's page 60,
360. Yes,
and the heading is method of application.
yes,
What if I'm straight at 3.4?
yes,
Page 6.
yes.
Document kindly read the statement. If the bidder is a limited company or a corporation, the application cell is signed by a duly authorized person holding power of attorney for signing the application, accompanied by a copy of the power of attorney. So this is clear, Lord. It may be right or it may be wrong. If you have any objection, you could have challenge this clause, Lord. You preferred not to challenge. You preferred not to take any clarification from the department. You submitted your bid. Now you are, after rejection, you are saying that it was not right. Okay, but my submission will be this petition is not prepared to be issuing a notice from possible business. But I have my not basically this documents go there. But it's burden the technical ability with my and my technical capability. So my work experience and all other documents are therefore listed in clause 20 that you upload based on. Based on that, my evaluation of the.
You see, it says,
These are ancillary documents.
just listen,
These are ancillary.
just listen. It says that if the bidder is a limited company or a corporation, the application shall be signed. What application is this?
The tender.
So this application shall be signed. So it has to be signed by a duly authorized person holding power of attorney. Now, it was signed, but it was not signed by duly authorized person holding a power of attorney. Correct?
Person-
So he may be authorized according to you as per the
He was
Companies Act,
authorized, he was not holding a power.
but he is not holding a power of attorney. Correct? Then,
Because as per section 21, my lord.
And it
not
says-
so.
for signing the application accompanied by the power of attorney. It should say accompanied by
Why
the
should
power
I-
of attorney.
Why, being a company director, why should I appoint an agent? Power of attorney creates a contract of agency. When I am the principal, when the principal himself is signing, why should he create an agency, my lord?
Well, this,
Attorney general is an agent.
this is the requirement of the tender.
My lord.
If you are not challenging the tender clause, if I could have
I
understood,
cannot, because I participated. my lord. I
correct,
participated, I
no,
cannot.
then if you
What I am
part,
saying is that.
you cannot now,
secretary or-
there is a judgment of the division bench, which says that you cannot, after losing out, you cannot turn around and challenge the tender clause. Also. And out here, you have not even,
I'm not-
and out here, you have not even challenged the tender.
I'm not challenging therefore, because I have participated. I'm asking that, my lord, there's a question of interpretation.
No, there's
Whether this
nothing
is
to
mandatory
interpret.
or it's not mandatory. Because the company law says something else. The clause of course says that we give it. But I know, why should I appoint the agent, my lord?
Any citations in your favor?
Hello?
Any citations in your favor?
No, there's no clear citation. But then, of course, there are cases where the apex
There
court
are
has said that
many,
have
there
been
are
mandatory
many citations in his favor.
Of course, it's heavily loaded, man. Heavily loaded. That's something. Both deciding for the tender committee also took the opinion of the land. So it's very clear.
Is there any pre-bid meeting?
There was
Is
none.
there any clause,
Here, my lord, there was no big.
pre-clarification clause or something?
Normally in some tenders it is there.
There's nothing. Anyway, but then when was the last date of submission of this?
Submission have happened,
When was the last date of submission of the bid?
submitted in March, my lord. The tender is of March. The curriculum of 7th of 11th.
Anyway, right, then. Heard this. B. Patha, learned counsel for the petition.
3rd of April was the last.
Also,
Yes,
also heard Mr. P. Nayak, learned additional AG, additional AG for all the respondents.
No, no, sir. Fine.
All the respondents. For respondents number 1 to
4 and 5.
1 to 3. 1 to. Who is 4 and 5?
4 and 5 might not have the persons who were might not
Selected.
technically there. It is not yet finalized, then they were technically.
Right. The petitioner is agreed with the minutes of the bid evaluation committee held on 25/6/2025. Wherein the petitioner's technical bid was declared non-responsive on the ground that the petitioner had not submitted the original power of attorney for signing the bid document. In terms of clause 3.4 of the information and guidelines for bidders, bracket section dash Roman 2 dot technical bid. Right. Which states as follows, Page 103, It's here, I put it in blue. Okay. It's in bold. Next part. The no, next part. Clause 3.4 of the information and guidelines for bidder required that the bid document were to be signed. No. Required the bid document to be signed by a duly authorized person holding a power of attorney for signing the said bid document. If the bidder was a limited company or a corporation, the bid documents were also to be accompanied by a copy of the power of attorney. The bidder was also required to furnish memorandum of articles of association duly attested by a public notice. Next part. The petitioner's case is that the petitioner is a limited company or
We are a private limited company.
a private limited company.
We coming under the corporation.
Huh?
We coming under the corporation. Limited.
Private limited company, which would come under the word inverted commas corporation. Full stop. The petitioner being a company can be duly represented in contract matters by its director in terms of section 21 of the Companies Act 2030. Full stop. In the present case pertaining to the NIT dated 7/3/2025 for construction of a training institute at Dhamdhama in Nalbari on engineering and procurement construction bracket EPC that was mode 1 basis. Let's read whatever I said. One basis, inverted comma close. The petitioner company was represented by the director, by its director, comma, who had signed the tender document. However, the director had not been given any power of attorney by the company,
What resolution is it?
though there was a board resolution authorizing the director to sign the bid document. The petitioner's cause is subject that as a director can represent the company in contractual matters in terms of section 21 of the Companies Act 2030. There was no requirement for the director who had signed the contract document to have a power of attorney. As such, there was no further requirement of the tender document being accompanied by a power of attorney. What about memorandum of articles of association? You did not furnish it?
That I did it as per clause 20 of page 40.
Okay.
The 14 document to be uploaded by law.
The next slide.
By law.
The petitioner's counsel submits that clause 20
Of Part A, section 1.
of the information and instruction for contractors for e-bidding provided the list of documents to be filled in by the bidders scanned and uploaded within the period of bid submission. The said clause 20 provided for various documents. However, it did not include. However, clause 20 did not make a mention of the requirement of furnishing a copy of the memorandum of articles of association duly attested by a notary public, by a public notary. As such, the petitioner's bid could not have been rejected just because the memorandum of articles of association had not been uploaded by the petitioner. But there is one thing, out here it says furnishing. You did not furnish subsequently also. Did you furnish, did you try to furnish the memorandum of articles of association after the bid was opened?
They did not call for it.
They did not call for it.
I represented. But then.
Where have you represented?
I got page 106.
Look at your answer. You have not tried to submit at all.
We have not tried to submit.
You have not tried. You have said that since we are already registered, the objective need not be established by any other document and the registration would be sufficient compliant in this regard. As such, we request you to waive compliance to such non-mandatory clause. You have,
They tried to justify the non-submission.
they've tried to justify the non-submission. You have not tried to submit. That is the letter.
ROC certificate we have given. ROC certificate without my memorandum of association, how can there be a ROC certificate? Your page 71 again is the technical, my lord, details that of the company profile is.
You see, when
Company profile
the,
is submitted in page
and,
71 for me, my lord.
when the clause is there, we have got to
I
follow.
understand, the clause is there, I understand. But then they have created the confusion because for me also, lordship would look page 71.
You could have always later on said that I'm submitting it, please take it. Instead of that, you're trying to justify a non-submission.
Right.
Your case now, out here you have not talked about uploading. Out here you are talking about non-submission.
Uploading of right on you. petition was after the because representation is like a contractor.
Huh?
Representation was filed by the contractor.
What to do? So
At
he,
the time of drafting, my lord, this 14 documents actually uploaded into that. It's actually a confusion, but because organization structure at page 71 also they ask. They
you
also don't mention here anything. of the thing.
can't help you.
So otherwise the company profile will.
How to help you? There's no way.
They ought to have,
Huh?
they ought to have asked if this such condition, but otherwise my technical documents are there. Can always be because the memorandum of association is anyway a public document. It's uploaded on the ROC.
Like I said before,
I-
the requirement of the clause is there. You have not challenged the clause. Open eyes, you participated. What do you mean?
Yeah, that is, so I cannot challenge also now because after participation I cannot challenge. All I can therefore say is that these are not mandatory. Could have been overlooked. The
What have
main
I said?
technical part I have said.
Uploaded / furnished by the petitioner. The petitioner's counsel submits them. The registration of the petitioner as a company is granted only after verification of documents and credentials, including the memorandum of articles, the memorandum of article of association made by the petitioner. The certificate of incorporation is also based on such article of association. As the petitioner was already registered with the PWD building, I close from Assam, there was no requirement for the petitioner to establish the objectives of their company. And as such, the respondents should have waived non-compliance with the non-mandatory clauses. The non-mandatory clause, that is 3.4. He also submits that the bid submitted by the petitioner should be declared technically responsible. Next, Mr. P. Nayak, the additional AG Assam, submit that
First submission is that these requirements have been uniformly applied. If plotted comes to page 61, in case of partnership form also that requirement is there. 3.3. Similar is the requirement in 3.4 in case of a company. So first, my submission would be this requirement will be uniformly applied in case of either partnership form or company. Secondly, lot of language of that clause, not it's quite clear and no ambiguity is there. So it should not create any confusion. And thirdly, Lord says, it is for the authority to decide which clause is mandatory and which clause is declaratory.
correct.
What is the requirement of the bill? And fourthly, Lord says that if he has any region or confusion, Lord, he should have asked for clarification from the department. As it was open for the seller to submit the revised tender also. It did not do that. Secondly, Lord, it did not also prefer not to file any challenge against this law. So that is my point. What should be?
Okay, right. Mr. P. Nayak, the learned addiction, we submit that the requirement of the person signing the bid document by way of a power of attorney holder was uniformly implied, was uniformly applied not only in respect of a limited company or a corporation, but also in respect of a partnership firm. The petitioner, knowing fully well the implications of section of clause 3.4 of the information and guidelines for bidders, would have asked for a clarification with regard to clause 3.4. If he was not, if it was not interested in submitting a power of attorney, not submitting, if it was not interested in submitting uh, the technical document, the bid document signed by a power of attorney holder. The petitioner could also have asked for a pre-bid clarification requiring submission of memorandum of articles of association duly attested by a public note. However, the petitioner failed to do the same and instead submitted his bid with open eye. He submits that the question of whether a clause in the tender is mandatory or ancillary, is to be decided by the author inviting the tender. And the interpretation given by the author has to be respected. Anything else for this?
Language is clear now. No ambiguity.
Further, there is no ambiguity in the language of clause 3.4 of the information and guidelines for bidders. And the same should have been read along with clause 20 of the checklist of the information and instructions for contractors for e-bidding. That's all. Anything else?
Now, what about his presentation? It's not like he is requesting the authority that I'm going to submit my.
Okay,
It's
next
like-
para. The additional
He
AG,
relates the condition.
the additional AG further submits that not only has there been no challenge to clause 3.4, but the petitioner has not only has only requested waiving compliance with clause 3.4 on the ground that it is a non-mandatory clause. That's all.
Just try to justify not.
By justifying non-submission of the power of attorney and the memorandums of articles of. Yes, sir. I have heard the learned cause for the. In the case of AFCONs. Okay, I will basically dismiss. Dismiss. Dismiss.
Item 13, your lordship. Yes, initially, your lordship, we have being agreed by closure of the
Newspaper. When, which year?
lordship and
Which year? Closure, which year?
so 18 euros.
2000?
16 euros.
Huh?
18.
2018.
Lost. Now, your lordship, what has happened, your lordship? The award was against us, your lordship, put that proceeding. Now, your lordship, since this has been closed for so long, your lordship, my clients do not want to participate. that way. And your tax, your lordship, only prayer will be your lordship. If your lordship comes to last page of the petition, your lordship,
Page?
page 116.
Yes.
From the decision of the issues, reference in question can be answered in the following manner. The management was justified in closing down the establishment without prior approval from the government. Second one, your lordship. The employees are entitled to compensation under section 25FF, 25F of the IDS. This part, your lordship, only they want your lordship.
They want what?
That as per your lordship.
That is already there.
Lordship. That is your lordship.
That's already
More than
there.
that, is there.
Huh?
Already it is.
Already there.
Lordship, that, since your lordship, it is
So when you
pending here.
close it, 2 or 3 months, no salary they get it. It is already effective
That
judgment.
is already there.
That they want the more than that. That
Yeah,
there
he has
also
not
may
given
be
this amount.
No, this they have to come and they, on the basis of the judgment, they have to represent these are the employees. They want, at least they should come forward.
So
They
that
will
we will
not
do
come
in
forward.
the, before
They
the
went
labor
for,
commission.
my lord, the problem is they went for litigation before this item. In suppose areas in this particular deal which we are running, then that particular some areas in respect of budgeters wage board.
That's
So
the
that
difference.
has already, no, this is some employees did not accept that amount. They put and they challenge it. So now already it is accepted. So what they can do, they let them file a representation before the management. These are particular, it is as per the judgment.
Not so that observation will enough.
Heard Mr. S. Bhatt, Madam Counsel for the petition. Also heard Mr. D. Das, the Senior Counsel, assisted by Mr. T. Chakraborty for the respondent number 2. Who is for respondent number? Mr. G. Bokalia appears for respondent number. Mr. S. Bhatt, Learned Counsel for the petitioner submits that the petitioner the petitioner is not interested in pursuing the matter any longer and would like to withdraw the present writ petition. On considering the prayer of the petitioner's counsel, the writ petition is dismissed as withdrawn. Full stop. Next part. In view of the awards
It's 7/2019.
award dated 16/7/2019, passed in reference case number 2 of 2018 by the Industrial Dispute, Industrial Tribunal Assam. Wherein it has been held that the employees are entitled to compensation under sections 25 triple F and 25F of the Industrial Disputes Act 1947. The compensation amount should be given to the petitioner to a petitioner as and when they approach the learned tribunal. When they approach when they approach
Respondent number one.
respondent number 2.
And also one.
One and two. One and two.
One.
This has become more easy for the court side. But this has become very difficult when you decide a tender matter.
I think this was. So you have demolished it. Well, right. No one appears for the petition. All for the respondent number 3. Correct? You are for the respondent number 3. Yeah, no one appears for the petition. Miss,
In the medical. But
Miss
FS,
F.
S,
F.S. Hussain appears on behalf of Mr. S.A. Bhatia. Let us ask for the respondent number 3. Mr. P. Nayak appears for the GM. Mr. P. Nayak has submitted letter dated 18/7/25 issued by the Associate Planner, GMC, which states that the demolition of the unauthorized construction could not be executed due to the recent induction of newly transferred office staff members and zonal engineers being assigned inspection duty of cleaning and maintenance of sanitation at the Kamakya temple for the Ambubachi Mahayog from 1925 to 28/6/25. Full stop. However, the demolition of the said unauthorized construction would be executed shortly. Full stop. So, the next paragraph. Right. The Ambubachi Mahayog had been concluded in the month of June. And today it is 19th July. 18th July. 18th July. There is no reason for the GMC not to act upon its own orders. This is the matter. When? After 20?
eight.
After 20. This is the matter again on 1st August. Sent back the LCR. This year.
method disposal. Your losses will just see page 44.
Page?
Page 44. This matter was fixed my lord by them for hearing my lord. The final order has been passed on 13/5/25.
And then our chairman supposedly the day of the
So similar method, my lord, the common court directive, my lord, the remanded said the method, the authority, my lord, to pass a capital. There was areas for much more money. That my lord, we have deposited, we have submitted defense and deposited 50 lakhs.
How much are you supposed to deposit?
Hello?
How much are you supposed to deposit?
Well, 50 lakhs I have deposited.
No, altogether, how much how much are they demanding?
397.
Huh?
397.
397.
Yes. Out of which that's I deposited.
Only.
Let them pass a people order, whatever they will say. Let them pass final order.
Instruction is said that no hearing was called for, was not, hearing was not conducted.
Okay.
So if they appear for the authority, they have to get authority.
Okay.
In terms of page 40.
Okay, right. Third, Mr. G.S. Savara, learned senior counsel for the petitioner, assisted by Miss K. Bhattacharya. Also heard Mr. R. Sharma, For respond to Mr. G. Bokalia, please for respond number. Okay, then you take this last order, second paragraph, third paragraph, huh? Then you write. Mr. G. N. Sayawala submits that the petitioner had been given a letter dated 6/5/25 from the Secretary cum Commissioner Board of Trustees, Assam Tea Employees Provident Fund Organization, requesting him to appear before the Honorable Chairman Board of Trustees on 13/5/25 at 11 a.m. in the board's office, Nidhi Bhavan, Vasistha Lanati, NH 37, Guwahati, -29, practical stamp. This is at page 44, huh? Along with necessary deposit challans that document in support of deposit of arrear PF contribution and any other deed. The petitioner's counsel submits that the petitioner did not appear.
Wait for some time, my lord.
Wait for some time.
My lord,
Wait for some time to appear before the Honorable Chairman Board of Trustees. And till date, no meeting has been held between the petitioner and the Honorable Chairman Board of Trustees. In pursuance to the letter dated 6/5/25, issued by the Secretary from PF Commissioner, Board of Trustees. Mr. G. N. Sayawala, Secretary and City Council Subsystem. Date for the meeting may be fixed, on which date the petitioner shall appear before the Chairman Board of Trustees and the PF contribution, area PF contribution that is liable to be paid by the petitioner should be clarified by way of an order by the Chairman Board of Trustees. Mr. R. Sharma appearing for the respondent number 2 and 3 submits that. Okay, Mr. G. Pokalial for respondent number 1 and R. Sharma for respondent number 2. Submit that they have got no objection to the prayer made by the petitioner's counsel. In view of the consent of the parties, do we fix the date or Board of Trustees? In view of the consent of the parties, the Honorable Chairman Board of Trustees, Assam Tea Employees Provident Fund Organization shall fix a date for a meeting to be held with the petitioner. Thereafter, the Honorable Chairman Board of Trustees shall pass a order stating the area PF contribution and other dues that may be payable by the petitioner. That's all.
no course action.
Till then, no coercive action should be taken by the respondent. List the matters accordingly. Close. Dispose of.
Because they.
Close.
Satisfied, will be satisfied with the have to come again.
Yes, this. It is accordingly disposed of. The petition is accordingly. What?
Obliged.
make decision worship, madam. Madam, here the PT, respondent number 1 and 2, they have filed affidavit yesterday, madam. When I refer to file reply, madam, only 7 days, madam, possibly fix it there. Because the small matter issue involved, madam. Okay, okay. Yes. So Mr. B.K. Das, Learned Counsel for the petitioner, submits that affidavit in a position has been filed by the respondent number 1 and 2 yesterday. Yes. And he needs a week's time to file a reply. This is a matter on liberty.
And the second, fourth of August. Fourth of August.
Both of us.
The sanction has been received by the government and it is sent to the director of it. And the director will send to the treasury. Petitioner will receive the.
Petitioner will receive the payment within 10 days. This 22 lakhs. So we close the contempt. Okay, right. Miss
I have pressure on behalf of Mr. Akila.
S. Vaishya appearing on behalf of Mr. S. P. Das, Learned Counsel for respondent number 120, submits that the amount of rupees 22,44,000 will be paid to the petitioner within 10 days. And in this respect, she has submitted the financial sanction letter dated 11/7/2025, issued by the Skill Employment and Entrepreneurship Department. This is the matter. If in August after 10 days. 10 days, are you sure? 10 days? Give a date. After 10 days, going for why not? Taking up feeling. I know. I know. Let's let her do her part. Okay, right. Miss, your name? Yes, Vaishya shall also play instructions as to whether the sealing proposal has been submitted by the department to the finance department pursuant to the financial sanction letter dated so, huh? Okay, you have to submit a madam sealing proposal. Once is then sealing proposal, then only money. 10 days, so might not be. It's fixed up is very low. Okay. It is? Where's the office note? Office note. Yes. You can that states office service has been taken and affidavit file and taken not against C and A. You are appearing for whom? And for the PC similar phone number 1. Miss R. Ram appears for the petition. Mr. L. Bora appears for respondent number 1 and 2. 1 and 2. Mr. A.K. Gogoi. P.K. Gogoi appears for respondent number 7. What about 4 and 5? Mr. G. Bokalia appears for respondent number 4 and 5. Good. What about 3, 6 and 8? Phone number 3 and 6. It is the board madam. Right. Yes. Office note indicates that there is no return of service or AD card. No return of unserved notice or AD card from respondents number 320. The petitioner has submitted an affidavit, next para, dated 27/6/2025, showing that not showing that, to the effect that Dusty service of notice that notice had been served to Dusty service to the Basugaon Municipal Board. Bracket is point number 6. On 25/6/25. However, there is no return of, however, there is no one representing point number 6. Huh?
Yesterday, I have received a letter from this petitioner to appear. He referred to this yesterday.
Oh, you'll be appearing for 6 also, so sit there. So here, yeah, Mr. S. Bora at this stage submits that he has received a letter from the respondent to the effect that he will be appearing for the respondent. Who is for 7? You're for 7. When are you filing an affidavit? Huh?
Will not file.
The respondents are granted how much time? 2 weeks time to file affidavit. Leaves the matter on. Interim order to continue till the next one.